Wherever it is practicable.
Last month, the High Court in Kampala dismissed an election petition that was challenging the election of Kawempe North Member of Parliament, Muhammad Segirinya, on technicality. In her ruling, Justice Henrietta Wolayo observed that there was no proof that Segirinya, who was incarcerated at Kitalia prison at the time, had been served.
In the premises, the petition is rendered redundant for non-service and is struck off the record.
The same court also dismissed the petition by Fred Nyanzi Sentamu, challenging the victory of Kampala Central Member of Parliament, Muhammad Nsereko, on grounds that Nyanzi failed to serve Nsereko.
We are talking of a litany of so many.
The rate at which election petitions are being dismissed on technicalities rather than merits of the case has raised alarm in some sections of the public. Most of these technicalities are preliminary objections raised by lawyers before hearing of the case begins. Some of the grounds for dismissal include failure to serve the petition, the time the petition was served, where the affidavits were commissioned, the lawyer's practicing certificate, and the license of the lawyer's chambers. Dr. Businje Kabumba, a retired constitutional lawyer and law don, says dismissing a petition on technicalities is wrong because it infringes the rights of citizens to elect who they want to represent them in Parliament.
Election petitions are special because you're not just dealing with the rights or interests of private parties, two litigants, as is the case in ordinary cases, because ultimately whoever wins or whoever sits in Parliament represents the views of an entire constituency. And it's important that the right person be in Parliament.
If citizens' rights are being violated, then who has interest in disposing these petitions?
Judges are few and overworked. It's the truth. So I can understand why some judges would find a technical ground to dismiss a case because very cynically it reduces their workload.
Dr. Daniel Ruhweza, also a constitutional lawyer, says even before going into the merits of the case, the practice is that a party is bound by its pleadings.
So for example, questions to do with names. That's why you hear many times people are writing or swearing statutory declarations saying, I am Ronald Daniel Ruhweza, but I have documents that say I'm also Daniel Ruhweza Ronald. 2, affidavits. Affidavit is testimony that is in written form, that is submitted to support the petition. And therefore it's very critical that whoever is swearing that evidence knows exactly what they are doing.
So between the petitioner and his or her lawyers, who is to blame for the faulty petitions and affidavits presented before court?
But I think the role is on us as legal practitioners, the officers of court that are guiding the petitioner in making the petition, guiding the people swearing to support the petition, that they do and swear the right thing.
Article 126, Clause 2E of the Constitution states that substantive justice shall be administered without undue regard to technicalities.
That article has almost been rendered dead because of certain interpretations that say, procedures, the handmaidens of justice. So we have put the Constitution down and we have raised statutes and rules of procedure. We'll put them at the same level of the Constitution and in some cases even higher than the Constitution, and I think that's a very big mistake.
We normally refer to that article as the straw of a drowning man or the straw of a drowning lawyer, that when you have nothing you can argue. That is what you normally rely on to the court to try and plead with the court. But Article 26(2)E normally has not been that convincing to the judges in the face of a clear law to that effect.
After the 2011 and 2016 polls, many election petitions were also dismissed on technical grounds. So what is happening today is not a new phenomenon.
The main interest at stake is the member of the constituency. Because imagine being represented in Parliament for 5 years by a person who should not have been in Parliament. How do you remedy that situation?
Hearing of election petitions ended on 16th September. However, what is now left are cases pending judgment. GILLIAN NANTUME, NTV Tonight.